Hi, welcome to the next episode of EHO Knows, or this episode's going to be known as Law and Order EHO. So this is where we're going to go law and order style out into the field and then into the courtroom and discover how your ability to get your message across in the courtroom will either let the guilty party off or will see your work coming through to fruition and an outcome that you're after. So law and order EHO. And to help me along the way, I've got Jason Scarborough. And I came across Jason recently because he's about to be doing training sessions specifically on helping environmental health officers prepare for court. So welcome, Jason. Thank you for coming
Oh,
along.
no, my pleasure, Shane. Thanks for inviting me.
Now, tell us a little bit about you. Who are you? Where are you? What
Yeah,
do you
no
do?
problem. Yeah, well, look, I run my own business, JS Regulatory Services, and we do, as the name suggests, is provide regulatory services, not just to regulators, but to people who are also subject to regulation as well. But in the regulator space, we do a lot of skills development and assist regulators like EHOs to undertake their important duties in a efficient and effective manner. And the prospect of going to court is something that does make people sort of take pause and get a little bit concerned about what may happen. So in that sense, I like demystifying that process, simplifying it so that people can feel a little bit more comfortable about the process.
Yes. And just to be clear, the purpose of this episode is one, to scare the crap out of anyone listening to it. I really don't want to go into court. But two, to then actually say, hey, wait a minute, if you do it right, you don't have to be as frightened. So we're going to be playing both. And so we're going to go through two different scenarios. And so story number one, what's the
Yeah,
background to
yeah,
it?
sure, Shane. Look, this was my very first experience in court, and I was working for a local council at the time, and I got a call that someone had identified a large amount of asbestos cement sheeting that had been dumped in the garden and tree waste pile at the landfill. And checked out, verified that yes, it did contain asbestos, and remediated that area and removed it. And with the support of my boss at the time, we did an investigation then, looking at records. I mean, this was 20 plus years ago, so CCTV wasn't really a thing. So we had to rely on paper records in terms of who came to the site and when. And looking at the time frame, we really only had one possible contender who could have done it, given the amount of material that was delivered in one go.
Okay, so now from the law point of view, how much time have you now invested in doing this sort of
Oh,
stuff?
in doing the investigation, it was reviewing records, interviewing and taking the sample and sending it off. So, look, all up, it was probably about a month and a half on and off, with other duties, obviously, because like everyone, I didn't have the luxury of just focusing on that one thing at the time. But yeah, we got to a point that, okay, look, certain based on the evidence that we have, that this company is the offender. Yeah.
And so down to one person.
Yep.
So now honing in, what happened
Well,
next?
yeah, so I won't name the alleged offender, but it was a large waste company. And so we issued an infringement notice. Basically, the legislation that was in place at the time allowed us to do that. And so we issued an infringement notice to this company with a letter explaining why that was done. And in very short order, we got a court election. So basically, they wanted the matter heard in court. Yeah, and look, that's the price that we pay for not living in a dictatorship. People are allowed to disagree with each other, and sometimes a third party is required to resolve that disagreement, and that's exactly what the court is, essentially.
Okay, so in your mind at this stage, it's clear that it's this one person, you've done all your homework, and you're going slam dunk, here's the penalty. They've said, get nicked. And so you're stepping into court now, feeling confident, feeling unsure. How's it going
Yeah,
for you?
look, feeling unsure basically, because my briefing before the actual court matter, which as the primary investigator, I was definitely going to be called as a witness. My briefing was 5 minutes outside the courtroom with the council's lawyer, who mainly looks after contracts and things like that, didn't do a lot of sort of criminal stuff. And he said, "Oh, look, you'll be right. This is easy. Don't worry about it. Just answer the questions and you'll be fine." And that was it. And yeah,
Yeah.
yeah. So that was my briefing, and then my first experience inside of a courtroom was being called as that witness. I'd never set foot inside a courtroom prior to that day, and just the surroundings and the people, and I suppose the seriousness of the whole thing. Yeah, you feel it when you walk in, particularly when you haven't experienced that before.
So if you're a newbie now, would you recommend that if you've never been into court, just walk in, know what it looks like, get a bit of a
Oh
feel
yeah,
for it, or
absolutely, Steve. Yeah, look, that's one of the big messages that I give at the training I do is have a talk to your boss, call it skills development, and have a look at the local court list. You want to go to a hearing. You don't want to go to a mention because they're just procedural sort of stuff. So you want to go to a hearing where you are actually able to observe people giving evidence, because if that's what you're going to be doing,
yeah?
that's the second best way to learn is to watch someone else do it.
Okay, so newbie walking in and you've hit the stand.
Well, the first of all, I was asked if I wanted to take an oath or an affirmation. I had no idea what the difference was between the two, and I had to politely ask the magistrate, "I'm sorry, Your Honour, I don't know the difference between the two." And yeah, he was good. He explained the difference, and so I chose the appropriate one for me, and then took my seat in the witness stand and got to tell my story. So, counsel's lawyer basically got up and said, "Okay, well, tell me what happened." And I explained the process from beginning to end about how we found this asbestos contaminated material, how we then went through records, interviewed staff, and then narrowed the list of potential offenders down to the defendant. And I was feeling pretty good at that stage. I was feeling, okay, yeah, look, I told my story, no objections, like and I'm going to show my age here, like on LA Law. Generation ago, the defence lawyer didn't get up screaming objection, so I must have done something right. So I'm feeling pretty good at this stage.
Yeah, then he's on your
Yeah,
side,
exactly.
and
Yeah.
so you're giving an opportunity to a friendly person to give your
Yep.
piece, and then suddenly the lawyers change and you hit part
Oh
two.
yeah. Yes. And you hear stories of corporate shark lawyers, and this was definitely a corporate shark lawyer. And over the next 20 minutes, I was thoroughly eviscerated. That's probably the best way to put it. At one point, I was so flustered that I had no idea how to answer a particular question, because I suppose I was thinking too much ahead about where this is going, which I learnt later is a big flaw. You just answer the question that you're asked at the time. And in my mind, I'm trying to picture when I'm asking these questions, where's this leading? Is this going to a trap? Is this, is the hammer going to fall on me if I answer this way? And I got myself wound up in a knot, basically. Yeah, so after half time, I was feeling less than confident about proceedings after that. And definitely breathed a big sigh of relief when I heard those magic words from the magistrate saying, "You're excused."
So what were the types of questions that you were just
Yeah,
hammered with?
sure. Look, there was a lot of sort of leading questions. So I remember one of the questions was, "So, Mr. Scarborough, am I right in interpreting your actions as being very prejudiced in that you targeted my client?" And of course, I said no. And the lawyer, she said, "Well, can you explain to me how your investigations only led to one person? A thorough investigation should lead to several options." And of course, I didn't have an answer for that because the investigation did lead to one person. So to be completely honest, it did make me look a little bit foolish and not very credible.
Yeah, that's a funny one, isn't it? Because you should have multiple people, and you're going, wait a minute, it says who? There is no universal law that says it should come, but you're on the
Yep,
stand, and your brain's just going, I don't know what to
yep,
do.
yep.
So how often should someone turn around and say, I don't know, I don't remember, that's not my area of expertise, rather than feeling like they
They
need
need to
to
answer.
answer a
Yeah,
question?
look, I have the 80-20 rule of cross-examination. So, the 80-20 rule applies to most things in life. And when you're being cross-examined by a defence lawyer, it is aimed to have 80% of your answers being yes, no, I don't recall, and can you repeat the question? If you stick to those four,
Okay.
if you stick to those four for answers that for questions that you can give those answers to, because sometimes you might be asked a question where you are invited to give a bit more of a narrative, and in that case you keep it as brief and as short as possible. So classic example, again, and I use this in the training, a good defence lawyer can say, can you tell me what this is, right? And the answer to that, if you're under cross-examination, is yes.
And then force them to actually ask, what is it? And
and look, that I know it seems like a bit of silly bugger sort of games, but it's just that discipline of answering the question that you're asked. And the upside of that, it does make the defence lawyer look a little bit silly as well.
Yes, because they're asking stupid questions.
Yep.
Yes. Okay. So any other questions really, you remember all these years later?
Things like, how can you verify the accuracy of the documents? Well, I couldn't, because they were made by 3 different people at various points during the day. And again, having a firm to tell the truth on the stand, I knew from the interviews with the staff that those records are often not complete. Sometimes they're busy, sometimes they make an incorrect entry. So I couldn't say that those records were 100% accurate. So it just little things there that a good defence lawyer will try and find the thin edge of the wedge to push into your story and then start prying it apart.
Yes. Had you made any mistakes during the investigation?
Look, personally at the time, I didn't think so.
What mistakes have you made?
Exactly, yeah. Yeah, well, after cross-examine, I was thinking, God, did I do this properly at all? So the defence lawyer did their job perfectly in that sense. But yeah, at the time, I can put hand on heart and say, look, I did the best I could with the time and resources I had available to me.
And so, things like, can you validate these? There are obviously things that you don't do during the process, and then in hindsight you're going, oh yes, I should have done that. How important are they to making or breaking the case? Like, if you stumble across one, should you be panicking at that stage?
Yeah, look, it's not fatal, particularly if you're talking like local court, because local court's a little bit more easygoing than sort of land environment and Supreme Court. Things like that question, how can you verify that these records are 100% accurate? And if I've said no, the magistrate may have had a rates notice delivered to him the week before that's got an incorrect spelling for his street name or something like that. And he's like, well, of course they're not 100% accurate. It's local government. They make mistakes all the time. So that's not a big deal. So yeah, often it's a case of just answering the question that you've been given. Yeah, the magistrate will sort out, what's a big deal and what's not.
Okay. So in this particular case, how many witnesses were there?
Yep, so there was
side?
actually 2 witnesses. On the prosecutor's side, there was just myself. There was just me as the investigator. Yep. And the really quirky thing about this was that for the defence side, there was 1 witness as well, who was the driver of the actual truck concerned at the time on the day.
Yes.
And another important lesson I learnt, and when he was cross-examined, he actually admitted to depositing that waste there. So he admitted to depositing the asbestos waste at the landfill. But the magistrate still dismissed the charge at the end of the proceedings because he misunderstood what that confession meant. And that was an important lesson that I learned on that day as well. Strange things can happen when you walk inside a courtroom.
So you had a slam dunk live in court confession, and yet the judge failed to actually realise what had just been said.
Yeah, or misunderstood what was said. And even though the counsel's lawyer tried to point that out at the time, the magistrate was like, no, matter's finished, sorry, got to move on.
Wow.
Yeah, and so that's, again, as I said, strange things happen inside a courtroom, and sometimes you have to leave common sense and logic at the door.
Yes. Okay, how much was the penalty?
From memory, it was, at the time, so about 20 years ago, $250.
Wow, okay.
Yeah.
And then they took it to court, and so it's a couple $1,000s in now modern terms, but it's still peanuts.
Yeah.
And you're using that as an example of not being prepared, panicking on stage, and then the lawyer having an absolute field day with you.
Yep, they absolutely do.
Okay, let's now go and just jump onto the second story. What's the scenario around the second story?
Yeah, so the second story relates to my time at the Environment Protection Authority. So we received a call about quite heavy sediment loads coming down a creek, and I was sent out with a colleague of mine to investigate it. And when we showed up at the complainant's address, sure enough, the water going down the creek looked like it was chocolate milk with the amount of sediment that was in it. So we followed it upstream, and we didn't have to go too far, where we found an excavator actively at work while it was raining, mind you, pulling willow trees out of the banks and the creek bed just upstream. And he wasn't too gentle about the process. He was basically digging out around the willow trees as the creek was flowing through where he was digging, obviously picking up a lot of sediment. And and then pulling these trees out, releasing more sediment. So so we took some water samples, heap of photographs, heap of video, interviewed the person doing the work on site, and at that stage again, I thought, right, well, I'm pretty sure the analysis results for these samples are going to come back like sky high with sediment. We can show that upstream was unaffected. We can pinpoint where the works were. We can say who was doing the works. Happy days, we're good. And this one was a little bit more of a serious matter, so we didn't issue an infringement notice for this, but we actually took it to the Land Environment Court because it worked out that the person had asked for consent to do the works and had been refused, then went and did it anyway.
Okay, so they knew they were doing the wrong thing and were caught with the smoking gun. So you rock up to court, and what happens?
Yeah, well, I might go back a step though, Shane. The briefing experience for court this time was vastly different. The EPA was using a barrister to argue their case on their behalf in court, and it was a whole afternoon basically with this barrister saying, take me through the case. What happened? What did you do? Tell me about the sample results. Tell me about the interview that you did with the person. And again, she wanted to know everything about what I did. And then she proceeded to tell me, okay, look, we've been advised that the defendant is defending themselves, so they don't have legal representation. And the first thing that popped into my mind is an old saying that a person who defends themselves in court has a fool for a client. And she said, because this person's defending themselves, the judge will probably give them a lot more leeway than what they would if he was represented. So just making you aware that there could be some shenanigans from the defendant. So
the defendant can push the boundaries further. They can ask inappropriate questions. And so in one sense, if you're against a lawyer, they have to play by the rules. And now you've got someone where the rules have been slightly put aside.
They can be bent a little bit. Yeah, absolutely. Yeah. So, but yeah, look, I left that briefing feeling, and I actually remember my first experience in court after that briefing and thinking, wow, that's just chalk and cheese. I'm fully informed as to what to expect. We've gone through the evidence they fully understand it. Yeah, we're super prepared, which is the ideal situation.
So an environmental health officer now going into court, are they, because times have changed, going to get more time with the lawyer beforehand? Or are they just as likely to have a 5-minute briefing?
Yeah, look, it really depends on the lawyer and I suppose what role that they have. So like if it's a hired counsel that does work for the organisation, it'll probably be a much shorter briefing. And I hate to say this, it's like any professional area. There's sub-areas that have specialisations and complexities. And criminal law is definitely one of those ones. And if you're actively practicing the criminal law on a regular basis, then you're not going to be 100% familiar with the practice and procedure and what to expect. Yeah. Whereas if it's, say, an in-house counsel for a local government, for example, that's pretty much all they do. Court-elected fines. So they're all over the process, so they can provide a much better briefing. Yeah.
Is it worth having your boss or colleague take that role and take you through the evidence and ask questions?
Yeah, look, any good investigation process should have that sort of let's stop and evaluate at regular intervals.
So what you're saying is that even before you get to court, you're saying regularly you just need to be fundamentally asking yourself, have you got yourself covered? And you don't want to be asking yourself those questions as you're walking into court.
Oh, God, no.
And then suddenly go,
God, no. My time at the EPA jokingly said that the best defence lawyers were our lawyers, were the EPA's lawyers, because they went through our evidence and the case with a fine-tooth comb, and if they found even like a small hair on it, we were given the option, okay, we need to get more evidence to deal with this issue, or it's done. So yeah.
So just like Law and Order or whatever, you get that moment where the lawyers are sitting down with the cops and going, okay, we can prosecute this one.
Yeah, absolutely.
Yeah.
Look, and different organisations have different risk thresholds for that. My experience with the EPA, their risk for the threshold was very high. They preferred walking into court, 95% certain that they're going to get a positive outcome. Say the police, for example, their threshold's a little bit lower, where they can be more inclined sometimes to say, look, let's put it before the court and see how it goes. So, yeah.
Yes. Okay. So the big day arrives.
Yes, the big day arrives. So again, as the lead investigator, I was the primary witness in this matter. So first of all, I had to wait for half a day in the waiting area outside the courtroom, which is, a special agony all in itself, because you can't really do anything, you can't go anywhere, and your mind starts working then in terms of
double thinking yourself.
Yeah.
What am I going to say?
Yeah, exactly. Yep. Yeah. So then,
Any advice?
Sorry, any advice?
Any advice?
Yeah, take a book, something unrelated to, because if you're not across the evidence at that stage, you never will be. So cramming at that point is not going to help. It's just going to raise your anxiety and fluster you. So yeah, take a book that's hopefully not like a crime novel or something like that. Something different that takes your mind away from what's happening. And I suppose nowadays with phones, games on your phone, yeah, even something like that. Like a Tetris or a Candy Crush or something like that. Just something to take your mind away from what's going to happen and just relax. So then the sheriff calls me to come to the stand. I'd been to inside the Land Environment Court before, so I knew what it looked like. I knew where people were sitting, who was who. I knew where the witness box was, so I didn't have that awkward moment asking people where I should go. I knew if I was going to take an oath or an affirmation straight away, so that wasn't a problem. And some good advice I had from the EPA's lawyer. He said, look, just take your time, adjust the chair. There's like a pitcher of water and glasses. Pour yourself a glass of water, get comfortable. And when I see you're comfortable, we'll start asking the questions then. And it makes a huge difference, because you sort of make that witness box your sort of little fortress then, if you like. This is where I'm here to do business and answer questions. So yeah, my evidence, or the evidence in chief as it's called, it went for about 2 hours, and our barrister was very good in that she was able to give me a little hand every now and again in helpful questions like, so what happened next, or did you do anything else after that? Because they're not allowed to ask leading questions as such, so they can ask things like, what did you do after that, what did you see, tell me about what happened, that sort of thing. So those big open questions.
So filling in the gaps of what they know you needed to say,
Exactly. Yeah.
because they're prepared beforehand.
Yeah.
It's just that you haven't got around to it yet and given you that chance to introduce it.
Absolutely. And it makes a huge difference when your lawyer is fully briefed on the evidence and they understand it, because they can. And it happens when you're on the witness stand. You might forget a detail, and they might say, was anyone else there at the time of your inspection? Oh yeah, there was actually, my colleague, Mr. So-and-so. So you can fill in those gaps that they identify. Yeah, so that went for about 2 hours. And then those dreaded words from the judge that it's your witness, Mr. Defendant. And then I did not leave the witness stand for 3.5 days after that.
Whoa.
Yeah. And I was cross-examined on everything from my educational background to my experiences, my expertise in identifying water pollution, my expertise in identifying pest tree species, you name it, I was asked about it.
So as you're being cross-examined, it's not just what you did, it's not just the evidence, it's who you are. Fundamentally, how are you even justified, entitled, presumptuous enough to be on stage? So it is personal.
It can feel very personal, like, and again, that's some advice that I give, is that it may feel personal, but it's business. It's a business it's like a business dispute that's being adjudicated by a third party. Unfortunately, the rules are a little bit different for people doing cross-examination, or the cross-examiner, than the person assisting the evidence in chief, in that they can ask leading questions, they can attack your character, they can delve into your qualifications and education and your experiences, because that all goes to your credibility as a witness, and they're entitled to explore those issues.
In my last podcast, I was interviewing Sarah, and she was raising the issue that environmental health officers are now being expected to do more and more, stepping outside of their areas of expertise. And so this very much is one of those, well, wait a minute, you are going to be potentially going to court over things that are now stepping beyond your area of expertise. And so it is an interesting piece of advice. Keep it professional. It's not personal, but yeah, just realize that you will be questioned. And so do as much of your homework beforehand, years ago,
Yeah,
months ago.
yeah, no, absolutely.
Yeah.
And look, a tip for your listeners and viewers, and one unfortunately that I see across all regulators, is make sure that your authorisations and delegations are in order. That is an area that I find with alarming regularity is not done properly. So people think that they might be authorised, say, under the Protection of the Environment Operations Act as an authorised officer, and they may not be. Okay, and that obviously has implications if you are exercising powers and functions under that act that you don't have the power to use. And that's an express pass to getting a case kicked out of court, basically. So yeah, if there's
Wow.
one big takeaway,
So you've got the slam gun, smoking
yeah,
gun, but because you picked up the smoking gun over there instead of over there,
yeah,
it's
yeah,
gone.
yeah, because you weren't properly authorised or delegated to do that task on behalf of your employer, the whole lot can get thrown out, and then it's off to the pub for commiseration beers, basically.
Okay, so a couple of days of being cross-examined.
Yes,
Did you meet your 80% rule? Yes,
I
no,
had that.
please
Yeah,
repeat.
I had that
I can't remember.
squarely in my head when I was at times being screeched at by defendant, and and if anyone's been to the L&E court, you'll know that it's very, civil and ordered normally. I think this defendant had been watching too many courtroom legal dramas, and at one stage he was right next to the witness box with a photo, like an A3 size photograph, screaming at me. And fortunately the justice at that stage said, look, okay, let's...
Yeah, but at that stage, you've now got someone yelling at you. You have to be taking that on board. Any tips on your stress levels are going up or whatever? How can you deal with stress
Yeah, look,
on the stand?
again, I think that 80-20 rule is great, because then you're focused on what was the question that was asked and how I can answer it. And even though it might be, 6 inches from your ear being screamed at you, you run it through that process. It becomes less personal. Like, okay, I'm not a fan of how the question was asked, but I'm going to give you the answer in a civil manner, and I'm going to answer the question that I was asked.
Yes. Any horrific questions that he
Oh
asked?
yeah, yeah, yeah. He somehow got hold of my uni transcript. It might have been in my personnel file with the EPA. I don't know, but pointed to a fact that I had a fail withdrawal on my transcript, and said, "Oh, this isn't very, becoming for a professional officer of the EPA and things like that." And unfortunately, I had to relive the fact that it was as a result of a family crisis, health crisis that was going on at the moment, and I had to actually, suspend my time at uni for about 3 months to deal with that, and I had no option, given that when it occurred, to actually, fail withdraw from that particular unit. So no, it didn't feel nice, I'll be honest, to delve into bad memories of past events, but again, I just answered the question that was asked. I didn't divulge any more detail than I had to.
So, yeah, getting back to some of these are really potentially personal. Stop them being personal. Answer the question. Move
Yep.
on. Don't try and second guess where it's going
Yeah.
to. Just answer the
Yeah,
question.
and
Um,
and and never ever ever get into an argument. Yeah,
okay.
yeah. So don't get into a ding dong battle with the defendant or the defense lawyer on the witness stand. A great saying that I heard one of the EPA lawyers tell me once was, arguing with a lawyer is like wrestling with a pig. You'll both get filthy, but the pig loves it. Yeah.
Yes. And at the end of the day, it's not the lawyer you need to
No.
convince. It's the
Yeah, the
judge.
judge or the magistrate. Yeah.
Got this guy who's screaming at you, a foot in front of your face. Um, he just looks like an idiot.
That was
You don't have to justify yourself to
Yeah,
him.
and that was the end result, basically. And there was a couple of times when I was answering questions, and I sort of, I normally answer my questions, direct the answers to the judge or the magistrate, because, as you said, they're the person that needs the information, that is making the decision. And I did catch a couple of slight, eye rolls from the justice on occasion when questions were being asked. So yeah, I mean, they're not idiots, judges and magistrates. They can tell when, someone is having a lend, being a difficult personality is probably a diplomatic way of putting it. Yeah.
Yeah. in one sense, they're on your side because their job is to deliver justice and you're presenting a infringement, but they're against you because you have to do your job correctly.
Yep.
So from that point of view, yep, they're there, good guy, bad guy, but ultimately you should be just seeing them as being on your side. It's someone that you have to just demonstrate that you've done your job so that they can do their job.
Yeah, they're the key person in the room that you tell your story to so that they can make an adjudication on what they believe to be the facts. So, yeah, and you're right, they are in charge of what happens in the courtroom, and they will pull you up if you step outside the rules of evidence or you're breaching some other protocol, but the reverse also applies. So, yeah, if the defence lawyer is being overly aggressive or pushing the point beyond what is deemed reasonable, they'll pull them up as well.
Yes. So a couple of days cross-examination, and the final outcome is...
The final outcome is something called a Section 10, which some of your viewers may be aware of. It means case proven, but no conviction recorded. So we secured a guilty verdict, basically, but under the act that governs the punishments that can be applied in court, basically that's an option that the justice has to say, yep, it's been proved beyond reasonable doubt, given the circumstances, I'm not going to record a conviction or impose a penalty.
Yeah. Side note, why? What was the logic?
The logic was, as I found out later, and I'm glad I didn't know at the time, apparently this particular defendant was a bit of a serial pest with government and frequently abused the Freedom of Information Act process as it was at the time, had several other litigation matters pending in court against government and government agencies. So yeah, for whatever reason they thought, look, he's spent however much of his time, he probably did have a lawyer briefed at some point. The time and cost penalty associated with doing that is sufficient.
Wow. Okay.
Yeah, the time and cost spent by the defendant defending this matter is probably equivalent to about what a penalty would be in any case.
Yes. Okay. The two stories though, first story, not prepared and definitely a bad outcome. Second story, properly prepared and then getting to a guilty Section 10.
Yep.
So mostly the outcome that you're after.
Yep.
So chalk and cheese, difference being prepared beforehand and knowing what a court looks like, knowing what you're about to be going into when you're on the stand, not being flustered, sticking to yes, no, I don't know.
Can you repeat the question?
And please repeat the question. I've learned something.
There we go.
At the end of the day, there's only one person in the courtroom that you need to convince, and don't bother fighting with someone who's just trying to get you riled up, unhinged or whatever. Any other tips?
Yeah, look, something that is often overlooked, I suppose, at the end. Okay, we've finished court, job's done, great. If you've had a bad experience on the witness stand, it doesn't have to be, the case has fallen apart because of your evidence. It could be that you've just been asked some really pointed, personal questions. That can upset anyone. And I suppose the big piece of advice is that dwell on it, don't ruminate on it, talk to someone about it. I was a big fan of after court beers, so I'd go with my colleagues and we'd have a bit of a laugh and a debrief about what happened. Did you hear this question the guy asked me? Did I answer that all right? What do you reckon? Get it out, get it off your chest. And even if you're really feeling great about what's happened, definitely make use of your sort of employee assistance program sort of stuff. Talk to them about it. The worst thing you can do is just sort of bottle it up and sit on it, because it'll come back the next time that you have to go to court. That's the first memory you're going to go back to, is that, oh God, this was such an unpleasant experience. This is just going to be worse. And then, it cascades from there.
So your very first experience, bad experience, could have just followed you.
Yeah, easily. But I had
and
a very...
I
was going to say, I had a very supportive boss at the time, and we went to the pub afterwards, and he said, dude, tell me about what happened. So I'll be honest, I was a bit reluctant at first because I thought, oh God, I'm going to look like an idiot. But no, he was really just tell me what happened. It's not a failure if you don't learn from it.
And so then the big lesson for, if you're the boss, then the two things that you must do is make sure that your team member is thoroughly prepared before they step in, knowing what they're getting into, knowing the types of questions or whatever. So you need to make sure they're equipped. And then at the same time, the moment they step out, you need to be saying, hey, how are you going? How have you dealt with it? So as the boss, beforehand, afterwards, 100% your responsibility, you can make a huge difference.
Yeah, absolutely. It makes all the difference. So
Fantastic. And if you go in having done the training, you will have been even more better off. So in the links, we'll drop something for the training sessions, but you run them fairly regularly by the looks of it. So
yeah, so at 3HA, we're at least doing one a year, and depending on demand, I can definitely talk to Sarah and Co. If there's additional demand, we can do more.
but if you miss out on the training, talk to you personally.
Yeah, absolutely.
And
yeah, no, I'm very happy to.
Yeah. No, thank you very much for your time today. So, Law and Order EHO, we've finally done an episode. As long as we don't have to do World War Z EHO,
Yes,
we'll be
yeah,
set.
that'd
So,
be good.
thanks a lot, Jason.
No worries, Shane. Thank you.